Today the talk is going to be on due diligence and its implications on insider trading. And what we will do is I will probably spend about 40 minutes or so just going through the presentation, and then we can have ample time after that for the discussion if that's okay. So we can proceed in that fashion. So the topic really came about in a sense from a practice perspective to start with, but it has a broader policy level implication and some theoretical implications as well. And the reason was for quite often in most countries, not just in India, there's always a struggle while doing due diligence in M&A transactions, but particularly for share acquisitions, and how that can be dealt with in terms of insider trading regulations. So to start with, I think we're all familiar with why one needs due diligence. And most M&A transactions, especially those which have a large size, would go through due diligence investigation. Usually the acquirer conducting a due diligence on the target, but sometimes the target conducting a due diligence on the acquirer if the acquirer is going to discharge consideration in the form of issue of its own shares. So due diligence is basically more of an investigation, so to speak, into the affairs of a company. And so basically the idea is for the economists, if an acquirer is going to buy a company, from an economic perspective, a value would have been imputed to the acquisition from the acquirer's perspective. And the reason why a due diligence is done is in order to ensure that the value that the acquirer assumes is in the company is in fact there. And I'll go through some examples which will make this fairly clear as well. So when we think of a due diligence, it is primarily an investigation procedure. And this is a contractual investigation, right? So it is done through a contractual arrangement, through negotiations between the parties, where the acquirer will look into the affairs of the target. And due diligence can go across a number of different streams. So due diligence can be on business due diligence, it can be on financial due diligence, tax, and legal due diligence as well. So a number of streams of due diligence is usually carried out in order to ascertain the transaction. So from an economic perspective, I think the key part is what is the purpose and outcome of the due diligence? What does due diligence tell us in the end? The first issue is the most significant due diligence outcome would be that once the acquirer has engaged in a discussion with the target for a possible acquisition, there is something that is discovered during the due diligence that is so severe that can even amount to a deal breaker. So if the value of what has been discovered in the due diligence is very significant, or if it's what has been discovered is extremely sensitive in nature, for which the acquirer does not want to take a risk for, the acquirer may simply walk away from the deal. So that's kind of the extreme situation as to what could happen during due diligence. The second one is more common, and I think that has kind of finance or economic implications, which is that the outcome of the due diligence will result in a reduction in the value of the transaction. So just the way a deal would typically start is the acquirer and the target may come up with a ballpark benchmark figure for or the price for the transaction. But that price is going to be subject to due diligence, because at the time that the price has been fixed in the initial stage, the acquirer does not know enough about the target. So what happens in the due diligence is things start getting discovered. The value of the assets may not be what it has been projected, or there could be more liabilities than what has been projected. Both of those could result in the value of the deal being reduced as a result of due diligence. So this is a scenario where it's not so bad that the deal is going to be terminated or the acquirer is going to walk away, but that results in a discussion or renegotiation of the price so as to ensure that the price truly reflects what the ultimate discovered value of the company is as a result of the due diligence. And then, of course, due diligence will also help for other reasons, primarily for transaction structuring. So I don't want to get into the details at this stage, but for example, it would even help the parties to negotiate the structure based on the findings of the due diligence in terms of who should buy whom, who should merge with whom would depend on the assets and the liabilities of the respective companies, and that is also an outcome which arises out of due diligence. And finally, due diligence also helps from a contractual perspective, it helps in including what is called deal protection devices. So for example, if you find that there's a problem with the title to the assets of a company, then you would add more representations and warranties that the seller or the target would give to the acquirer, so that the contractual protection for the transaction is going to significantly be enhanced as a result of the due diligence. Or you would ask for an indemnity if there is a potential risk. So if there's a risk that comes out during the due diligence, there may be ways of addressing that through contracts, and that is also an important outcome of due diligence. So in a nutshell, these are the reasons why parties would carry out a due diligence. As I said, there are a number of different branches of due diligence, and it's essentially a collective exercise which looks at all of these things. And some of the more sensitive types of due diligence include tax, environment, litigation. So these are aspects that gain a lot of importance when we think about due diligence as such. So the question then is, again, in what sense do we think about due diligence? From a information asymmetry perspective, the first question is, when you do due diligence, and I think it goes back to the question that was asked in the beginning, is to what extent should an acquirer rely on information that is already available in the public domain? And here there's a distinction between what happens in listed companies and what happens in unlisted companies. So in unlisted companies, there are a lot of, there is no disclosure regime, and therefore due diligence becomes very important because unlisted companies are not transparent and they're not subject to securities regulation, due to which information is not available in the public domain. Whereas when we come to public listed companies, information is already available in the public domain, and therefore the acquirer can either take a view that it is going to acquire shares based on the information that's already available in the public domain, or it can say that it wishes to look at the information which is not already there in the public domain. So to that extent, in a listed company, due diligence may tend to be marginal because disclosure of information is required by securities regulation, and to that extent, a lot of information is already in the public domain. So the question that we have in terms of due diligence and its concerns with insider trading only arises when it comes to public listed companies. And the reason why this arises, again, I think it goes back to the question that we've been trying to consider, is that it causes information asymmetry. Because the acquirer is given information as part of the due diligence, which is not available to the other shareholders of the company. And to that extent, there may be a preferential treatment that is provided to the acquirer that may fall afoul of insider trading regulations. So why do we say that there could be a concern as far as insider trading is concerned? The first issue is regulations on insider trading deal with information that is not already in the public domain. So what we are referring to is unpublished information. And the second is the information which is unpublished is material in nature. So it is not something which is very minor. It is significant because that information may also be price sensitive. It may have the ability to move the price of the company, of the shares of the company, one way or the other. So really what we are referring to is price sensitive information, and some of the examples are already on the slide. It could be M&A transactions, declaration of dividend, buyback, etc. And so when we think about inside information, largely we are referring to what is called unpublished price-sensitive information. So when I use the term inside information as we go along, the technical definition, especially in the Indian context, is referred to as unpublished price-sensitive information. So what is the problem that we are faced with that we need to take into account? So the kind of context that we are considering is, on the one hand, we want to have due diligence, even in public listed companies, because due diligence might actually enhance the ability of the acquirers to enter into these transactions, which may actually be value enhancing for shareholders of the company. But on the other hand, due diligence in public listed companies may give rise to certain other issues, which primarily relate to information asymmetry between the parties, whereby the acquirer has more information than the other shareholders of the company, and therefore that could result in potential misuse of the information. So in a nutshell, what we're trying to see is this kind of a conflict between these two scenarios, and it's really this conflict that we are considering in terms of how to resolve this in the legal context, and also from a theoretical perspective. So the paper that we are kind of looking at here, the core argument of this is that from a theoretical perspective, what we are trying to do is to reconcile the goals of the acquirers in entering into the transactions on the one hand, and what the objective of insider trading law is on the other. So how to reconcile these two positions is important. And the second question is, as we see, the due diligence actually gives rise to some kind of a temporary asymmetry of information, where the acquirer has more information. But as I will explain in a little bit, this asymmetry of information can be recognized or adjusted through certain methodologies, which is what law follows, mostly in the case of due diligence, which is information asymmetry is only temporary because the asymmetry gets adjusted by restoring parity before the trading. So the way the mechanism works, and I'll talk about that a little bit, is the way to reconcile the two is to ensure that the acquirer discloses the inside information before the transaction takes place. And a lot of the jurisdictions that we're going to talk about, that's effectively what happens. So the acquirer does the due diligence and then discloses the information and puts it out in the public domain before it actually trades. And this kind of announcement is something referred to as cleansing mechanism or a cleansing announcement. So you issue the cleansing announcement and then carry out the transaction thereafter. So to simply put it on a pictorial way, what you see is that the dark blue aspect on the slide is basically the acquirer and the level of information that the acquirer has. And the light blue is what all the other shareholders have. And if you look at the left-hand side of the slide, you see that before the due diligence, in theory at least, the acquirer and the other shareholders have the same level of information. And then during the due diligence and after the due diligence, the acquirer gets a greater level of information. So the level of information that the acquirer has increases over a period of time. But if you have a cleansing announcement, and which is what the law requires, at that point of time, when a cleansing announcement is made, and a cleansing announcement basically means that whatever inside information is available to the acquirer at that point of time, that information is released to the market before it actually trades in the shares. So that at the time that the trading takes place, there is a parity of information. So if that parity of information exists, then at the time of transaction, both the acquirer as well as the other shareholders have the same level of information. So this is typically the way it is possible, at least from a theoretical perspective, to reconcile the insider trading laws on the one hand and the need for due diligence. And to a large extent, as I will kind of refer to in a little bit, the laws in all the countries that we are going to look at follow this pattern to a large extent. So this is how the model seems to work as far as reconciling due diligence and insider trading are concerned. So, but this model works only if two other conditions are required and imposed. The first condition to be imposed on the acquirer is that during the period of due diligence, the acquirer maintains strict confidentiality. Because if the acquirer is not going to maintain confidentiality, then the asymmetry is going to flow around in the markets. And the second is what you would call a standstill obligation, that during the period that there is asymmetry of information, the acquirer will not trade in the shares of the company. So if you have this kind of a parity of information approach and you have the acquirer subject to these two conditions, the argument is that it's a win-win situation because the acquirer can do due diligence and carry out these acquisition transactions. At the same time, the other shareholders are not getting affected because at the time that the trading takes place, they have the same level of information going forward. So the purpose now, what I'm going to do in the next part is to try and see how this applies in 3 different jurisdictions which have encountered this problem and have tried to resolve this problem in many ways similar, but in some ways slightly distinctively from each other. And the 3 countries that we're going to look at are the UK, Singapore, and India, which has embraced this problem and tried to deal with it in the recent set of amendments to the insider trading regulations. So just in terms of what the framework is like in these countries, I won't go into the details of that, but the UK has a fairly elaborate set of provisions dealing with insider trading, which are both criminal as well as civil. So the criminal part is dealt with under the Criminal Justice Act, and the civil part is dealt with a legislation known as the FSMA, which is a legislation of 2000, and they have some subsidiary kind of regulation as well, which is the Code of Market Conduct and the Takeover Code. But a lot of this is getting in the process of being reformed because EU market abuse regulation is in the process of reformation. So in the middle of 2016, there's going to be a new set of regulations that are going to come out on an EU-wide basis. So that is, in a sense, it's in a state of transition, but at the same time, it also comes out with very interesting mechanisms to deal with this problem. And as far as Singapore is concerned, you have the Securities and Futures Act and the Takeover Code, both of which deal with this. And in India, of course, you have the SEBI Act as well as the insider trading regulations, which have only been recently reenacted in the Indian context. So what exactly is the problem from an insider trading perspective when we deal with due diligence? And here there are 2 kinds of problems. The first problem is what is called as a communication offense. And the communication offense is usually on the management of the target, because insider trading laws generally prevent selective disclosure of information from the target to any other person. So during the due diligence, if the target is going to give out information to the acquirer on a selective basis, then that could potentially fall within the purview of the communications offense, which is going to be something that needs to be considered, but that, as we will see, is allowed in certain circumstances. And the second aspect is what is called as a trading offense, which basically requires, which is something that is imposed on the acquirer. The fact that the acquirer should not be trading while it is in possession of inside information. So this is also sometimes called the dealing or the trading offense. So the trading offense is an obligation that is imposed on the acquirer, whereas the communication offense is more on the issuer or the company itself and its management, the people who are going to disclose the information. So what is followed in these 3 countries that I talked about is a principle or a theory called the parity of information approach. And the quote that is provided here is, in a sense, something that is emblematic of this approach. Because what this quote basically says is the focus is on the information the person has and not on the source. And more importantly, there is no focus on whether the person intended to violate the law or not. Right? So you just have to look at what the information is, and is that information in the hands of the acquirer. And intention does not have any relevance. And this is again something that is kind of within the realm of strict liability approach, which is followed in these countries, where the state of mind of the acquirer doesn't matter. It doesn't matter whether I had that information with a view to using that information to acquire these shares. All that is required is, do I have the information and have I traded while I had this information? Right? So these are the only two aspects that the law considers, which means it's quite an expansive scope of insider trading regulation. And to a large extent, we need to contrast this with the US approach, because the US approach follows what is known as the fiduciary theory, which means it is not just the possession of the information that is required. The information should have been obtained by breaching a certain duty. And that duty may have been owed to the company, or may have been owed to the shareholders, or even the source of information. And there's a whole jurisprudence about how the US deals with fiduciary theory. And there's umpteen number of cases that I don't think we need to worry ourselves with for the purpose of this discussion. But the US has much less stricter approach towards insider trading, because it's based on the existence of the fiduciary duty. But these three countries that we've talked about, that is US, UK, Singapore, and India, do not follow this US approach, because we follow a stricter approach on the basis of parity of information. But at the same time, there is an argument that why is the US arguably more active when it comes to insider trading enforcements? And there, perhaps one argument could be that it is the enforcement mechanism that is quite robust and strong. So despite a more onerous duty on the regulator to show insider trading, the enforcement apparatus is more active. Whereas in these three countries, there is a lower standard to establish insider trading, but maybe there may be varying degrees of enforcement depending on which country we are talking about. So given this background, to show that the enforcement, or rather the duty is quite strict, it is also necessary to see how regulators have enforced this. So for instance, in most countries that we are talking about, it is enough if you show that the acquirer merely had possession, and it is not necessary to show that the acquirer intended to use the information to trade or acquire shares. And that is the case in the EU as well, and there is this 2010 case which is from the ECJ, the Spectre photo case, where clearly there is a presumption that the moment the acquirer has the information and has traded while in possession of that information, that amounts to insider trading. But there is that presumption is rebuttable, which basically means that the person who's trading can say, no, I didn't use that information, but the onus is then on the acquirer in this particular case to show that the information was not used for the trading. And a similar approach is followed in India as well. In some of the cases, of course, all of these precede the new 2015 regulations, which have pretty much followed the same approach as well, which is that the presumption is mere possession is sufficient, and that would amount to insider trading, and then the onus is then on the person trading to show that it was not used for that purpose. And how do they establish that it was not used for that purpose? There are some examples that are there. So for example, if a person is routinely trading in securities, then one is able to show that they did not use that information because there's a pattern of buying and selling irrespective of what information was there. And the last one is also important and now has been included in the insider trading regulations in India, which is what is called a trading plan. So if a plan for buying and selling shares has been set out in advance, and this is very important for employee stock options, because employees will always be exercising their options and selling shares, and they can't be stopped. If they are to be stopped every time by insider trading regulations, that is going to create a problem. So planned sales of shares and trading plans are now being expressly recognized. So these are examples where parity of information has been addressed, but through other mechanisms where the rigor has been reduced to some extent. So in a nutshell, I guess this approach of parity of information basically, to a large extent, due to its strict nature and the fact that intention and motive are not relevant, make it very strict from the purview of acquirers, which makes it very difficult for acquirers. But the argument in this paper, and generally the way the law has approached, is the fact that limited parity of information is possible, as I said, if selective disclosures can be made, so long as there are cleansing statements that are made in order to restore parity of information at the time that the actual trades of the shares take place. So given this theoretical background, I'm just going to deal with two types of scenarios and how they have evolved when it comes to takeover, share acquisitions, and insider trading. And here there are two types of transactions that are involved, and both of these have slightly different mechanisms for dealing with insider trading. The first one is where share acquisitions have involved takeover offers, where a public offer is made to all the shareholders to acquire their shares. Can you do due diligence there or not? And the second is a scenario where there is no such takeover offer, and it's usually a case where somebody wants to get a minority stake, a significant minority stake in companies, and whether they should be allowed to undertake due diligence. So going through each one of these one by one. So going with takeover offers, due diligence, of course, is quite often necessary and accepted as far as takeover offers are concerned. And from a conceptual perspective, if you have a takeover offer, there is an argument that due diligence is probably necessary and beneficial. And why is it beneficial? Because the discovery of the price that is made in a takeover offer benefits all the shareholders, because all the shareholders are going to be made an offer at the same price, and that price may be a result of due diligence discovery, and therefore there is an equal treatment principle. All shareholders are subject to the equal opportunity rule. So there is an argument to be made that when there is a takeover offer, there is a greater reason as to why due diligence should be allowed, because if there's a due diligence, the benefit of that flows to all the selling shareholders who are going to be subject to the takeover offer. And this rule is recognized in all of these jurisdictions that we've talked about. And these are recognized in different ways in UK and Singapore compared to India. So for example, in UK and Singapore, it is possible for an acquirer making a takeover offer to conduct a due diligence. But what is very interesting, and this goes back to the first question that came up, is all the bidders must have equal access to information. So if there is bidder A, if there's an acquirer A who makes a takeover offer, and that acquirer is a preferred acquirer, that the target's management wants this acquirer and therefore shares the information, and if somebody else hostile makes a competitive offer, then the target must be willing to share the same information even to the hostile acquirer who subsequently comes. So if they ask the right questions, then in response to those questions, the same level of information should be shared. So to that extent, even when you have a friendly transaction, one has to be very clear that, or very sure at the time of due diligence, that whatever information is being shared with the preferred bidder might have to be shared with a bidder who may come in later, who may not be someone that the company really wants. So this really, again, goes back to the fact that all the bidders should have equal access. So this is one scenario where even a hostile bidder can have access to due diligence, and that cannot be denied because of this equality of information principle. But again, there could be different types of due diligence that is required. So for example, it's not just that due diligence is conducted on the company. The acquirer may have to talk to other people as well. So sometimes there is what is known as irrevocable undertakings. So in order to make the offer successful, the acquirer may have to talk to significant selling shareholders and then obtain their undertaking that they will sell in the offer so as to make the offer successful. So these discussions, etc., could also be price-sensitive information, but they are allowed by the law in the UK and Singapore. So in a nutshell, thinking about takeover offers, to a large extent, the law seems to be in favor of that. And the law, at least in UK and Singapore, explicitly provides for what is called as a safe harbor, where you can communicate this information so long as the offer is going to be made. And but again, this is done on the condition that before the trading actually takes place, before the shares are bought in the offer, there will be a cleansing disclosure, which means whatever was the inside information obtained in the due diligence will be made public at the time that the shares are acquired. Now, this can give rise to a lot of practical issues. So, how do you disclose information which has been obtained during a due diligence? Now, that's going to be very sensitive because this information may not have been disclosed for a reason, especially if it's not something that's allowed or required to be done under law. So how will you put it out in the public domain is one question. None of the regulations explicitly answer that question, but a lot of this has to be evolved through practice to ensure that you meet with this rule of having cleansed the transaction, but there could be certain sensitive information that still may have to be kept with the company. So what is price sensitive information? Who decides is usually the board of the acquirer who has the responsibility, because they ultimately have to decide when to put out that particular information. So there are gaps, as I've mentioned below, in how the regulations deal with it, but to a large extent, this is something that has in other countries been evolved through practice, and that would pretty much be the case in India as well. Yes.
Question. So when the cleansing takes place, so in the due diligence process, typically there's like thousands and thousands of pages of information which might be exchanged. So the acquirer can condense this and say that here is the gist of what I think is price sensitive information out of that, or?
Yeah. So normally, I guess if we are talking about a takeover offer, the best place to disclose that would be in the offer document itself that goes out to all the shareholders. So I would imagine that this would be included as information contained in the offer document, as opposed to explicitly stating that this is inside information, therefore we are disclosing it. So it would not be disclosed in a way by which it will be stated to be inside information discovered in the due diligence, but it may be disclosed in a subtle way, or it may be disclosed as information contained in the offer document, such that there is publicly available information on those aspects. So that would pretty much be the way it would be done in practice. So for paucity of time, one of the things that I'm going to talk about, again, a few other questions in due diligence, especially in a takeover offer situation. There are two other aspects that are quite important usually. The first is nobody makes a takeover offer without acquiring a few shares, right, in the form of a toehold, to acquire some shares, get a position in the company before a full-fledged offer is made. So to what extent can somebody acquire those few shares? Can it be before due diligence? Can it be after due diligence? That would also be an important question to consider. And to a large extent, it is not possible to acquire shares in the form of a toehold if at that point of time the acquirer already has inside information. So if the acquirer typically wants to make an acquisition of some shares before launching an offer, it's always good to do that before conducting the due diligence, because once you've conducted the due diligence, you have information which is inside information, and the only way you can acquire or use that information is to make the takeover offer. So stake building, as they call it, or toehold acquisitions would have to be done without being in possession of inside information, because otherwise it would fall within the purview of insider trading. Sorry, so it's stake building must precede due diligence, you're right, yeah. So one has to complete the stake building and acquisition before you conduct the due diligence. The other interesting aspect is, of course, whether you conduct the due diligence or not, one of the questions that often comes up in a due diligence scenario or an insider trading question is whether when I buy shares in order to build up a position, the fact that I'm going to make an offer subsequently, is that itself inside information? Right? So I'm buying shares and and amassing a small amount of shares. Only the acquirer knows that the acquirer is going to subsequently make an offer. But the rest of the market does not know that the acquirer is going to make an offer. So is the acquirer prevented from making that acquisition? Now, interestingly, both the UK and Singapore have taken the position that no, that is not inside information, because that is the acquirer's intention to make the offer. And its intention to make the offer is not inside information, because it's not an information that is obtained from the company. It is its own intention. It's self-generated in a sense. So the UK and Singapore both make explicit safe harbors when it comes to these kind of intention to acquire, but the Indian regulations on insider trading do not carry a specific regulation, but arguably one can still continue to make this argument that it is just intention. It is not information that's obtained from the company, and therefore there should not be a prohibition on insider trading. So these are some of the issues as far as takeover offers are concerned, but similar issues also arise when we think of acquisitions where takeover offers are not involved, right? So these are acquisitions of minority stake where no offers may have to be made. And somewhat similar issues arise even here, but with some differences. So when we think about acquisitions without takeover offers, there could be two types of acquisitions. One is in the secondary market. And the secondary market transactions could either be, when I say secondary market, it really means an acquirer is buying shares from existing shareholders as opposed to shares from the company. So in these type of transactions, the shares could be bought either through the stock exchange or through a negotiated off-market deal, or shares could even be purchased from the company as a primary market transaction. And these are generally known as private placements, or sometimes they're called PIPE deals, which is private investment in public equity. So a lot of these due diligence issues arise in this type of transactions as well, where the difference being that there is no takeover offer, where the shareholders, the minority shareholders of the company do not have the ability to sell their shares. It is just the acquirer taking a minority stake in the company, a significant minority. The only thing that the shareholders are allowed to do is the shareholders could vote on the transaction because it involves an issue of new shares, but shareholders cannot either accept or reject because they are not themselves party to the transaction. So one argument could be that there is limited justification for due diligence compared to a takeover offer because there is no equality of treatment involved in a transaction not involving a takeover. But as we see in a lot of, all of these jurisdictions, the approach that is followed is exactly the same, which basically means that the same approach of allowing for due diligence in certain circumstances, but which is followed through a cleansing announcement, is something that is considered to be permitted even in this kind of PIPE transactions. And in this particular case, the regulations in India are quite sophisticated and clear compared to other jurisdictions, because the law clearly says you can issue shares in you can give due diligence in shares not involving a takeover, but before the actual acquisition of shares, the information may have to be put into the public domain. And the difference compared to the question that you asked earlier is that here there is no offer document. At most, the offer document is what goes out to the shareholders in terms of the notice of the shareholders meeting, but otherwise there is no document that goes out to the shareholders. So how you disclose the information in the public domain and how you make a cleansing announcement is probably going to be a lot more tricky in this scenario, because there is no avenue to make that other than to say that this is the information that is out there. So this is something based on anecdotal evidence the market is still struggling. And I know that there have been criticisms of this approach, at least as far as the SEBI regulations are concerned, is how do we actually operationalize this? What is the avenue for us to put out that information without actually saying that this is what we got in due diligence, and without saying that this is inside information that we're now going to be making public? Because the law says at least 2 days before acquisition of the shares, the information should be made public. Yes?
Why is the concern that to state that we got this from due diligence?
Yeah, so you're right. So there is no concern. In fact, the law does not require that there is no requirement that this information, it should be stated that it was required in due diligence. So all that is required is at the time the acquisition is being made or 2 days prior to that, all this information has been put into the public domain. And the company can also do it. So the company or the acquirer, and normally in this case, it would be more appropriate for the company to put out that information as opposed to the acquirer. Because in the earlier case, at least the acquirer is going to put out the document, but here it is the company that is going to put out that information. So again, there's a lot of press coverage and critique about how would one operationalize this, because it would be a little odd to put out this information without kind of necessarily making it sound like it is for this purpose. But I suppose it's just to ensure parity of information. So again, we've talked about the same approach in due diligence in pipe transactions, where there is parity and cleansing. And as we just talked about, cleansing is more tricky when it comes to non-takeover related transactions. The other interesting aspect when it comes to private placement or pipe transactions is this concept of what is called market sounding. So it is, in a sense, it is linked to due diligence, but this could happen even in a stage even before due diligence. And this is a scenario where if a company approaches a number of investors in order to raise capital, can the investors go and deal in the shares knowing that the company is going to raise capital? So the only information they get from the company is not that they've done a due diligence, but the fact that the company is going to make a public offering, because that information itself could have an impact on share price. And potentially, some of the examples that we've seen in the market, it would depend on what is the nature of the information regarding the issue of shares. So if the issue of shares is for investment into a new business which is attractive, then that could have a positive impact on market price. But quite often, the fact that a company is going to raise capital could also result in negative impact. For example, if the issue of shares is to retire existing debt, or if in any case there's going to be significant dilution to existing shareholders. So what if a recipient of that information is going to deal with that information before that information is available to the market? So here we are the only information we are talking about is the fact that the company is going to raise capital. And for this, there's a lot. The UK is probably much more sophisticated and detailed when it comes to framework of how to deal with market sounding. And there the law has set up what is known as a wall crossing requirement, which basically means that when the company is going to raise capital and approaches several investors, the investors have to cross the wall, which means they themselves, in a sense, become insiders by agreeing to keep that as inside information and not to disclose or deal with that information. So the fact that you have been approached by the company to invest should be kept as inside information without dealing with that information. And one of the active enforcement cases that have come out in the UK a few years ago, which is kind of the landmark case on this, is a case involving the hedge fund Greenlight Capital. And so Greenlight Capital was is a company that held about 13% shares in a UK company called Punch Tavern. And Punch Tavern contacted various investors, including Greenlight Capital, about a potential fundraising. So the question then was, did Greenlight Capital want to cross the wall and become an insider and not disclose that information? So what Greenlight did was, Greenlight said, no, we don't want to wall cross. Don't give us that information. We want to continue to trade. So even though they did not wall cross, so to speak, they engaged in a telephonic conversation with the company. And during that telephonic conversation, some information was disclosed to the investor, Greenlight Capital. And what was the information? The information that the regulator found to have been disclosed included the fact that there is going to be a capital raising. The capital raising is going to be fairly soon. Second, then the capital raising is going to retire existing debt. And fourthly, that's going to cause a significant dilution in the shares of the company. So this information was given to Greenlight Capital, and the regulator found that Greenlight Capital, as soon as they got this information, went ahead and sold some of their shares, because they thought that this was not a good capital raising. And as soon as this capital raising was announced to the market, yes, the market price did drop, but Greenlight avoided the loss because they sold before this information came. And the Greenlight was imposed a penalty of almost £3.5 million for this particular transaction. So this is one of the largest enforcements that the UK has had, and it involved a market sounding type of a scenario, so which is a classic case of how this could occur. So we see that there is a fair amount of activity as far as UK is concerned, but in India we don't have any specific regulations yet as far as market sounding is concerned. So to a large extent it is left to practice and procedures to devise in terms of how information must be disclosed when market sounding issues come about. And even here, for those of you who are interested in the empirical aspects of this, there is a study which I'll share with you at the end, which has suggested that at the time of market sounding, generally there is a lot of activity in shares of companies, because obviously some of the information is out there selectively, and there is also some. The empirical paper also shows that when hedge funds are involved, the price movement is a lot more. So some of that evidence also does exist that market sounding is an important consideration that needs to be taken into account. What are the conditions? So as I mentioned, there are two important conditions that need to be satisfied for due diligence, and that's the basis on which this theory works. The first is that there needs to be utmost confidentiality as far as the acquirer is concerned, and the fact remains that the confidentiality should ensure that the acquirer, while it is in selective possession of information, does not disclose that information to anybody else. But the law has gone on to say, and I won't go through these cases for want of time, but they're on the slides and in the paper, the law clearly says that it is not just disclosure that matters, it is also important that there is what is called standstill obligation, that the acquirer does not trade in the shares during the period that it is in selective possession of information. So the confidentiality agreements need to also include a standstill obligation. So a lot of these cases that I mentioned on the slide are more about whether there was a standstill clause in that or not. So that was the case. So it's not enough to have a non-disclosure provision. There must also be a non-use and a non-trading provision, which is what is important for this type of theory to work. And the final kind of condition is something that we've touched upon before, which is that there must be a justification as to why information needs to be disclosed. So the information must be closely connected to the transaction. And in India, there is another very interesting condition that's been included, that the disclosure of the information and the transaction must be in the interest of the company. So the board of directors of the company has the onus of ensuring that this transaction for which the disclosure has been made is in the interest of the company. So coming back to this question of how do we deal with a block trade kind of a situation, yes, even if there's a disclosure, the board has to satisfy that it is in the interest of the company.
And not of the seller.
And not of the seller, because otherwise the company may or not, yeah. Otherwise, yeah, and also the company needs to have a justification as to why it discloses when the seller is benefiting from the transaction. So the final point is what one of you raised, which is what happens when the deal does not go through. And interestingly, this is one area where all the jurisdictions don't expressly deal with this scenario. And therefore, to a large extent, it is left to practice situations. So if a deal does not go through or it is unduly delayed, the question is, the acquirer has obtained information as part of due diligence. When can it start trading in the shares? And it can start trading in the shares when that information becomes public, when there is parity of information that has been restored. And in this kind of a case, it is tricky to make a cleansing announcement, because when the deal has not gone through, there is no incentive. The company will almost never make a cleansing announcement. And so this is another area where there's been a lot of representation, especially in India, for some more clarity on how to deal with the situation, because your normal cleansing kind of a scenario would not really apply. So if at some point of time the information ceases to be price sensitive, or it ceases to be confidential information, that is the time when the acquirer can start trading in the shares. And I don't think we can have like a single type of a scenario. It really would depend on the facts and circumstances of each case where that scenario arises. So when can the acquirer trade? either when the information is public or the information ceases to be price sensitive in nature. And it gets even more tricky if the deal itself is called off, right? So it's not about due diligence, but it's about the deal getting called off. And there, to a large extent, it depends upon whether the deal itself was announced in the first place. So has a takeover offer been announced? If the answer is yes, and if subsequently the deal is being terminated, there cannot be any trading in the shares unless that termination is announced to the market, because the termination of the deal itself is inside information. So that, I think, to a large extent is very clear. If a deal is announced, you can't trade until the information regarding the termination is also announced. But if a deal itself is not announced, right, you're kind of contemplating a deal that is inside information, but the deal is terminated. That's a more tricky situation where there is no answer, except to the extent that the FSA in the UK has provided a clarification saying that we don't always require to disclose that the deal which has not yet been announced is not going through. It really depends on the facts and circumstances of each case. So to a large extent, they've just left it to the market to deal with it, as opposed to having a single rule one way or the other. So finally, in a nutshell, I guess we've kind of covered a lot of issues. Due diligence is certainly important. We can't do away with it. As we saw, there is a lot of benefit, but it has to be balanced with insider trading regulations, and due diligence with cleansing requirement is perhaps one way of reconciling the two, and a lot of the details that we've seen ultimately boil down to both of these. Most jurisdictions have some way of dealing with it, but I guess as we've seen, there are some gaps in legislation that we need to think about.